ever make it to this point, all right? Because of the extensive nature of the discovery and because everybody is really fully educated on the strengths and weaknesses of their claim before they get to this point, I would say less than 10% of the civil cases that are ever filed go to trial. So this is where you're going to make your money as an individual or an entity if you're involved in a lawsuit. All right, let's talk first about some defensive considerations. What can you do to protect yourself and to protect your business if you're involved in a lawsuit or if you're served with a subpoena? We're going to talk first about some evidence preservation and document retention issues. Okay, what do you need to keep? How long do you need to keep it? What format do you need to keep it so that you don't get yourself into trouble with the court? Okay. Then we'll talk about control of your content output. What that means is who is responsible for posting your information. If you have a business social media platform, who is responsible for posting that information? What type of information are they permitted to post on that platform? Who controls it? And what gets to go out to the community at large? And then who has access to your accounts? Okay? I cannot tell you the number of times that we are involved in a contractual dispute between a company or an organization that uses a third-party vendor to monitor and post their social media. I think you guys raise your hand in the back. You guys do that? What happens if you get involved in a contractual dispute with the company that you represent? You guys are their gatekeeper, okay? You have their passwords. You have all of the access to their social media accounts. What happens then if you're the organization that has hired this third-party vendor and you no longer have access to your accounts? You have no longer, I mean, I can tell you that in my organization we have 150 plus employees. There may be 2 people in the whole organization that know how to access our social media platforms. So we'll talk a little bit about that. First, though, is preservation. Just to give you guys a little bit of the lingo, e-discovery is what we call discovery of electronically stored information. Okay, that can be anything from emails to social media content to PDF documents, online blueprints, anything like that. So everybody wants to know, how long do I have to preserve this stuff? What am I allowed to delete, and when am I allowed to delete it? Because these days, with the amount of information that is created just in the everyday running of a business, you can't keep it in perpetuity. I mean, you've got cloud storage and things like that, but you can't keep the information in perpetuity. And so the courts recognize that, and they say, if you have a well-documented document retention policy that says exactly when it is that you're going to delete, discard, purge your electronic files, and you follow that policy, you're not going to get in trouble for deleting information if there's a lawsuit. So let's say that you get sued, it's an employment law case, you've got an employee who is suing you for wrongful termination, they come back and they say, hey, I want my last 10 years of employee reviews. I want to know what the employee reviews look like so that I can show that I was a fantastic employee right up until the date of the hire. Well, what's the problem? Maybe you don't keep your employee reviews back 10 years. A lot of that stuff is stored online now, and a lot of these companies have storage requirements. What you have to do to be able to avoid some sort of penalty for not having that document in conjunction with the litigation is show, hey, look, we have a document retention policy. It's spelled out, it's well memorialized. We delete everything that's more than 3 years old or more than 5 years old, whatever the case may be. And if you can show the court that you deleted a document in conjunction with a policy, you're not going to get yourself into any trouble. Where you're going to get yourself into trouble is if you start deleting documents in response to a potential claim. Okay? So if you have a claim that comes in or a lawsuit that's initiated against you, and you go back at that point and start to delete information, whether it's bad or good, you're going to get yourself into some trouble with the court. It's called spoliation of evidence, and you can be sanctioned for it. They can dismiss your claim. They can give you monetary fines, those types of things. So the difference is whether or not the document was deleted as a response to a claim or whether or not it was deleted in response to a document retention policy. So if you do not have a document retention policy, either as it relates to your electronic documents or your actual paper documents, I would urge you to get one immediately and follow it because it will help you out greatly when the lawsuit begins. You can't claim ignorance as a defense to e-discovery requirements, okay? So you can't say, I didn't know that I wasn't supposed to delete it. It doesn't matter, the court's still going to sanction you. The best protection is to have in place a social media preservation policy and procedure or a document retention policy and procedure, all right? And so if you have, like I said, some sort of written documented policy that says when you delete and what you delete, you'll save yourself a lot of headaches if and when a lawsuit is initiated. All right, content control. Obviously, you as an organization, you can control your own content, okay? And so when a lawsuit is initiated, as long as you have control over your passwords and who is posting information, you can control the content that you put out there. Because the last thing that you want to do is post anything on social media relevant to the lawsuit, okay? As soon as a lawsuit comes in, you want to, number one thing I forgot to mention as it relates to preservation, you want to send out what's called a litigation hold letter, okay? Anybody within your organization that has control or is a records custodian for any type of record, whether it's your social media person, whether it's your actual paper file, document, or records custodian, you need to have a letter on file that you send out to each individual that's responsible for keeping your records to say, there is a claim, it is about this person, it is about this subject, do not destroy any documents relevant to this claim, okay? It's a great CYA, and it will protect you from inadvertently destroying documents, because the court doesn't care, okay? If the lawsuit comes in and you inadvertently destroy some document, okay, or delete some document, not in conjunction with your document retention policy, they're still going to hammer you, okay? Because they're not going to be able to tell whether it was inadvertent or on purpose. So what you should have your risk manager do, or the individual responsible for litigation control, is send out that letter immediately to anybody who's a records custodian. Say, do not destroy any of these documents. Do not modify any of our content. Obviously, the company can control its own content, but what can you do to control employee content? That's a big question, okay? Because the last thing you want to do if you've got an employment law dispute is have individual employees going back and forth on social media about the nature of their employment, or we fired so-and-so because she's an idiot, or whatever the case may be. It doesn't matter. People use social media for all of the wrong reasons. So what can you as a company do to control your employees' content? Well, first and foremost, you can control their use of equipment that you own, okay? You can control the use of your time that you pay the employee for, all right? And so if you have a social media usage policy, you can set limitations on when an individual is allowed to use social media on company-owned devices and what they're allowed to use their time for while they're being paid. A lot of people think, I've got a First Amendment right, I can post whatever I want, and you can't fire me, you can't discipline me. That's absolutely untrue, okay? Unless you work for a governmental entity, you can be fired for anything that you post online, okay? As long as it's not what we call a concerted activity. The National Labor Relations Board says if you are an employee and you go online and you are posting with other employees about the conditions of your employment, okay, hey, I don't like how much they pay me, or I think they should give us more breaks, or my manager's a jerk. If you're posting something about the conditions of your employment online, you can't be fired for that, okay? But if you're posting, pictures of you taking shots at the bar, in a tube top or whatever, you can be fired, all right? So there's really no First Amendment protection for online social media posting for employees unless it falls within this very narrow category. One other thing to think about is retaliation, okay? You cannot fire somebody for posting if it is like a whistleblower type situation, okay? So if somebody is posting online about they discriminate against, women here at my job, or they discriminate against people over the age of 60, if you were to then fire somebody as a result of that, it would constitute retaliation and you would probably get yourself into some trouble. But other than that, you can control your employees' postings, whether it is at work through work-related devices or whether it's off the clock, okay? If somebody posts something about a lawsuit and you don't want them to post it and you told them that they weren't supposed to post it, they can absolutely be disciplined or fired. The key here is to have in place a common sense social media policy that includes some provision about the use of social media in relationship to a lawsuit, okay? Generally, this can be as simple as a sentence or a paragraph within your social media policy that says, the moment that litigation ensues, no employee shall post or upload any content to social media, either from a personal or professional platform, about anything relevant to the litigation. Like, it could be that easy. And then in that situation, to the extent that you have an employee that violates the policy, you now have a documented reason to either discipline or terminate. So you can control the content of your employees. And then controlling access. It's very important for every organization that has a social media presence to have in place a procedure and a policy for who has access to the accounts. You never want to have a single gatekeeper, okay? A single individual who has all of the control, because of the fact that, like the example that I just gave you, what happens if that individual all of a sudden develops an adverse relationship to the organization? They get fired, all right? What happens if that individual wins a lottery and moves to Tahiti? I mean, there's all kinds of possibilities, so you want to make sure that you have in place a policy as to who has access to your accounts, who is able to post information, whether or not there is any vetting of the information that is posted on behalf of the organization. And if you have that policy in place, you'll avoid a lot of headaches if litigation starts and you've got to start controlling what you're posting online. Succession planning. This should be part of your succession planning, okay? This is a key individual within your organization, that individual that's responsible for your social media presence. It's huge. It's like your marketing person. And so you want a succession plan for both the sudden or planned departure of that individual from your organization. All right, so those are some defensive considerations. Now I want to talk to you a little bit about some offensive considerations. This is the fun stuff, in my opinion. All right, what can we do as an individual or an organization involved in a lawsuit to leverage what other people post online or what other organizations post online in conjunction with a lawsuit? Everybody has a social media account, all right? Most people keep a large majority of their social media information public. All you have to do is look. The very first thing that I do when I get in a new lawsuit is I provide a list of names and search terms to my paralegal, and she then goes on and does a comprehensive search of Instagram, Twitter, Facebook, Match. I mean, you name it. If there's a social media platform out there, she's searching it. There are companies that specialize in this, okay? Third-party vendors. You can provide that company with an individual's name, an individual's social security number, date of birth, and they will send you back all of the public social media content that's out there on the internet. And so if you ever have this take place, I would encourage you, as one of the very first things that you do, is look up your adversary online, find out what information they post on a public basis, preserve it, okay? Because a lot of times what happens is an individual is involved in an accident, or an individual has a bad termination with their employer. There's no lawsuit just quite yet. They haven't gone to see an attorney yet. You can go on there and preserve their social media information. Then they go see an attorney, and the attorney says, delete everything, okay? Because there's an ethics rule in Florida that says that you, as a plaintiff's attorney, can tell your client to delete adverse social media posting. So now they've deleted everything. What are you going to do? If you haven't preserved it early, you're not going to ever have access to that information. So I always instruct my clients, preserve early and often, even before I get involved, okay? And a lot of companies that I work with now hire private investigative companies. As soon as there's a possibility of a claim, they go on there and they preserve whatever social media content they can get. Written discovery, okay? Even if it's not public, we can ask for it, okay? I can send you a discovery request and say, please produce to me every single photo that you've ever uploaded to Facebook of yourself. Please send to me every single comment on Facebook that has ever mentioned the word whatever, okay? It is absolutely discoverable. If you can show any relationship to the lawsuit at all, and usually there's some sort of relationship, because in any lawsuit involving injury, like a personal injury lawsuit or an employment law case, you're usually the plaintiff is alleging some emotional damages, pain and suffering, those types of things. Well, what goes to pain and suffering? Well, if you're not partying with your friends the very next day, you're probably not suffering. I mean, one of the best cases I ever had from a social media standpoint was a middle school girl. She was on a bounce house, went down the slide, a couple kids came down behind her, hit her from behind, and she was claiming that she sustained some significant injuries to her neck. Chiropractic records didn't show a whole lot. We had some imaging studies, MRIs, x-rays. They didn't show a whole lot. But here we have a 14-year-old girl who's making all of these claims related to her inability to carry on her activities of daily living. She used to love to ride horses. She used to love to go ATVing, all of these things that she could no longer do, and it was a sad case. We found her MySpace profile. Okay, she used a fake name, but we still found her MySpace profile. This was back when MySpace was actually relevant. We found all these pictures of her from immediately post-accident, riding horses, going on ATVs. The claim settled immediately, okay? So there's a ton of information out there. Even if it's not public, we can ask for it. Subpoenaing the social media provider, all right? We can send subpoenas to social media providers asking for information, okay? Please send us every picture that John Smith has ever posted. Please send us every private message that John Smith has ever sent to this individual, okay? Some social media providers are better than others about producing. For example, Facebook will never send you information, okay? If we subpoena Facebook, they send you a letter back saying no thanks, unless you're law enforcement and it's in conjunction with, an ongoing law enforcement investigation. But for a civil lawsuit, you're never going to get anything from Facebook. But some of the other smaller social media platforms will provide information in response to a subpoena. Now, one thing you may not know about Facebook is they have this feature called download your information. Has anybody ever, raise your hand if you've ever used the download your information feature. Okay, we got 2 or 3 here. In your settings, you can go to your properties and your settings up in the little gear symbol in the corner. You can download your entire Facebook profile. It's amazing. I used to have a list of all the information that you get from it, but it's every picture you ever posted, every comment that you ever made, every time you've commented on somebody else's wall, everything. So this has been really big in litigation is we just send over a request to the other side to download your information. And the court loves it because they don't have to get involved. There's no subpoenas. They just say, hey, download your information and send the CD over to the other side. And then we get to spend however long we want perusing this individual's Facebook account and picking out what's important and what's not important. So that's something to keep in mind. One thing you never want to do is ask for a password and login for somebody else that's on the other side, okay? Even if they give it, even if you know it somehow, if they're required to keep that type of information on file, don't ever use a password and log into somebody else's social media account if it's related to litigation, because the first thing they're going to do is they're going to say you tampered with their site, and anything that's bad is something that you put on there. So regardless of whether they're willing, because I have attorneys on the other side all the time, they're lazy, they don't want to deal with it, they don't want to go through their clients' 40,000 pictures and pick out the ones that are relevant and irrelevant. So they say, we'll give you the password and the login, and you guys can go on there and pick out what you. Absolutely not. Okay. And if you don't give it up voluntarily, we can ask the court to make you give it to us, and the court will generally compel all parties to produce social media information. I put third-party vendors on here because there are times when individuals have deleted social media information. Okay. Get involved in a lawsuit, you get to an attorney quick enough, he says, go ahead and delete all those pictures of you down in Cancun the week after your accident. We then can't see it. Okay? If you go to the download your information feature on Facebook, it's not going to show up. Okay? But there are third-party vendors out there. We use a company called eHounds out of Tampa. They can go onto your Facebook account and they can find any picture that's been deleted. It's really amazing. It just reinforces kind of the #1 rule from this whole presentation, that anything that ever ends up on the internet never really goes away. All right? Even if you've deleted it, even if you've completely removed it, if the other side has enough money and enough time, they can find it. How do we use social media? We use social media throughout the entire course of the litigation. We can use it to draft pleadings. We certainly use it in discovery. We can use it to tell any type of case, okay? I gave you an example of a personal injury case where somebody's claiming pain and suffering, mental anguish, those types of things. You can obviously rebut that with photos of them engaging in activities of daily living or going on vacation. But think about an employment law dispute, okay? Somebody indicates that they're unhappy with their job. Well, go back and look at their timeline. How many times have they posted about being unhappy with their job versus how many times have they posted about being happy with their job? Or you're trying to figure out where somebody was at any given time. If they're a serial poster and they use Foursquare, they check in places on Facebook, you can figure out where they were at any given time based on their social media usage. There's really no limit to the amount of information that you can glean from social media. It's amazing how much they do. Mediation, this is really where we make our money with social media. It is extremely powerful to have a plaintiff give her sob story or his sob story about how they'll never be able to do X, Y, or Z again, and you to get up and just kind of slide a couple pictures across the table, and you can reduce the value of a claim or end a lawsuit very quickly with some appropriately timed presentation of social media stuff. Trial and trial preparation, we use it a lot for the cases that do go to trial. Okay, anyone ever served on a jury? Civil jury or criminal? Criminal? Civil? Criminal? Okay. I'm telling you, if you served on a civil jury ever, somebody has run a social media search on you. Okay? Every single case that I ever take to trial, I have an individual in the courtroom during jury selection. Her only job is to run every single juror through social media. I want to see what your political affiliations are. I want to see what organizations you're involved with. I want to see what sports teams you like. I want to see if you're from Ohio and you're a transplant or you were born down here, okay? And we get all that information from social media. I know more about you by the time that you sit down on that jury than you may know about yourself, okay? Because we are trying to pick those individuals who are going to best associate themselves with our clients. And so for me, as a defense attorney, I usually want somebody who's conservative. Okay, usually we try to pick folks who are married, who have long-standing careers, and so we look at those types of things online. Even political affiliation comes into play. So we use it all the time for trial and trial prep. Yes, ma'am?
I was just curious if you have to have like a release to do that?
Nope. Nope.
Like, what if a lot of people put their like my profile is all private?
If it's private, we can't get to it. But we can get to, even if you have a totally private profile, we can get to other information online. We can see your criminal history.
Sure.
We can see your political affiliation, those types of things. If you do have a private profile, one that is actually fully private, we can't get into it. We're not hacking into anybody's accounts out there. We are just simply picking out important information from what's out there in the public sector. So. But very good question. Privacy concerns. Everybody always raises privacy concerns, all right? I've got a right to privacy under the U.S. Constitution. The Florida Constitution has a specific amendment that gives everybody a constitutional right to privacy. My profile is not public, it's private. I've got all of these rights to privacy. You can't get my stuff. I'm here to tell you that we absolutely can. Okay? Every court in the state of Florida, whether it's a state court or a federal court, has ruled. I don't care if your profile is public or private. I don't care that the Florida Constitution has a constitutional amendment that says you have a right to privacy. You do not have a right to privacy in your social media information. Okay? And so if it's out there, we can get it.
Good picture.
Yeah, I like that.
Potential pitfalls. Social media content that can be attributable to a company. Obviously, the company's social media presence can be attributable to the company. But what if you have an individual that works for your company at a high level, some sort of manager or supervisor that has a professional Facebook or Twitter account that's out there putting information out there? It gets into kind of a gray area. Is that information that they're posting going to be attributable to the company itself? Especially during election time. People were all over the place with their posts, and it was just fun to sit back and watch. People tweeting and posting things on Facebook about their personal political views on certain subjects. Well, what if you're posting that? What if you have an employee, a manager, or supervisor that's posting that information, and then all of a sudden you get a discrimination claim? And they say, well, we're looking back, and one of your managers is posting about Black Lives Matter versus All Lives Matter, or whatever the case may be. Sometimes that can be attributed back to the company if you have an individual that's high level enough, and most of their posts are related to the profession itself. You can get yourself into some trouble with that. Employee use. Okay, this is kind of a big one for a lot of my clients. Do you monitor your employees' use of social media while they're out there doing their job functions? I can't tell you how many motor vehicle accidents I defend because somebody was Facebooking at a stoplight or before they got to a stoplight more often than not. Do you have some sort of policy in effect? Because if you don't have a policy in effect, and you have an individual who's using a work phone to access social media while they're driving on a job-related function, the employer can be liable for extra damages in some cases. Yes, ma'am?
I have a quick question. We have a company and we have trucks, international, nationwide.
Sure.
And we have a driver and he likes to post while he's driving down the road. And we've addressed this with him, and he's an excellent driver. I mean, he gets to where he's got to get to, he's making us really good money.
Sure.
This right here, he's a liability.
Absolutely. Yeah, if you, especially now that the company's on notice, that you've got an individual driver who, whether he's a good driver or not, is utilizing his phone during the course of driving the truck to post information, take photographs, whatever the case may be, now that driver gets into an accident. Not only are you on the hook vicariously because you're his employer, you knew about it. And you probably should have done something to stop it, and the fact that you didn't do anything to stop it might expose you guys to additional damages.
So that's vicarious liability.
Well, so there's vicarious liability, which says that any employer is going to be liable for a tort that their employee commits while they're in the course and scope of their employment. Right? So if I've got a company and one of my drivers goes out and rear-ends somebody while they're on the job, I'm on the hook. If I knew that driver was a bad driver, okay, and I still said, here, take the keys, I can expose myself potentially to punitive damages for gross negligence, okay? So like in your situation, you've got a truck driver that you know is out there using his cell phone while he's driving this presumably large truck around. He gets into an accident and kills somebody. They find out that that information's out there. They're going to say, what are you doing? Why are you letting this guy on the road? You know he's using his phone. It's gross negligence. And potentially you can expose yourself to significantly more damages.
So based on him driving, and if they are watching him in a mapping and date and timestamp, and he's posting at the same time that it shows him driving, and date and timestamp,
Absolutely.
then it's mirrored.
And you better believe they're going to ask for that thing. Every single motor vehicle accident case that I've ever had, they ask for the cell phone records of every individual involved in the accident immediately.
So this is something that we should be putting into a memo for our drivers.
Absolutely. Yeah, absolutely, 100%.
We actually put a memo in to pull over.
Yeah, absolutely.
And we want to see you stopped, because we have the tracking device, right? So we want to see you stopped on the map. You'll see him, you know. And I've called them and said, do you see me stopped? You know, just to test it
Sure.
out and make sure. And then they can see where you're stopped. I take a minute, I text, I do whatever I need to do, and then boom.
Especially with the interstate transport. You've got the Federal Motor Safety Carrier Act, which imposes some limitations on you all for uses of cell phones and mobile devices while you're driving their vehicles. I know that generally the only type of mobile device usage that's permitted under the Federal Motor Safety Carrier Act is through talking on the phone through a Bluetooth headset. That's usually the only thing that they're going to let you do. And so if you're in violation of the statute or the code there, you can open yourself up to additional liability as well. Most people do exactly what Steve said. They've got some policy in place that requires you to pull over, things like that. Best practices. In litigation, you have very little right to privacy in anything you post online. Okay, if you guys take anything away from this presentation, it should be that anything you post online is potentially discoverable and can be used against you. If you ever become involved in litigation, be cognizant of what you post online and don't delete any information potentially relevant to the claim unless it's in conjunction with a document retention policy that you have already memorialized. Okay? Send out your litigation hold instructions to inform those key people within your organization that are in charge of keeping your records not to delete anything. Litigants may have a right to compel you to produce electronically stored information even if you are a non-party. Okay? So if you get subpoenaed, you may have to sort through all of your records and come up with electronically stored information even if you're not a party. Have a clearly delineated social media policy in place from the start. Okay? Anybody have any questions for me? Yes, ma'am.
So on Facebook right now, I work at a hotel.
Okay.
And months ago, we had a mad person. So his car was damaged, and so it went through insurance, and insurance said it didn't happen. We don't have yellow markers. There was yellow damage done to the bumper, so we didn't pay for it. But he's pissed.
Okay.
And so he's saying, I'm never coming again. You know, they ruined my Mercedes. Rah 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 rah.
If it is your Facebook profile, then yes.
It's the business.
Yeah, absolutely. Yeah, you can delete the content. There's no harm in doing that. The problem that you have is if you post it on some third-party site that you don't have control over. There are, obviously, you guys are probably familiar, there are companies out there that specialize in repairing damage to reputation from bad reviews, online postings. But absolutely, if it's on your profile, you control the content that's on your page. Yes, ma'am.
Is there a statute of limitations regarding if your business, for example, is now closed? Can an employee from 3 years ago come and say, hey, there was sexual harassment while I was working there, but your business is closed?
Absolutely. Yeah. So the way that it generally works is every tort, sexual harassment, personal injury, has a statute of limitations. So if I go out and rear-end somebody, that individual has 4 years to sue me for that accident, okay? And so if I'm working for John Smith Roofing Company and I rear-end somebody, and 2 years later John Smith Roofing Company shuts down, 3 years later that individual decides to sue me and John Smith Roofing Company, somebody may have to respond on behalf of the company. Now usually what happens is there's an insurance policy, okay? And when you shut down your business, you buy what's called tail coverage, and that coverage will cover the company for any lawsuits for the next X number of years, whatever the statute of limitations is. Okay, so if you're ever winding down a business or business entity, you want to make sure that you have coverage for claims that come in after the entity is no more. Because sometimes what individuals can do is they can call it's called piercing the corporate veil, and they can go through the company that no longer exists and go to individuals that were principals in the organization and impose a personal liability on that individual. So, very important to get that type of coverage when you're closing down a business. Yes, you may have to go back and try and find records if you can, if they subpoena you, those types of things. But by and large, a lot of this stuff really is only going to come into play when you've got an active business that's involved in litigation. Sir?
Question, yeah. It seems like the policy writing is the most important part in this. Would you recommend going through somebody like yourself for the policy initially, or is that something the employees and management would sit down and?
Sure. Every organization goes about writing social media policy in their own way. I think personally, I mean, it's a selfish thing, but I think going to an attorney is your best option. I personally don't do it because I'm a litigator, but we have transactional folks at our firm that do employment handbooks that include social media policies all the time. There is a whole host of resources on the internet too if you want to do a DIY approach to social media policies. As long as you have something in place, you're better off than you were if you had absolutely nothing in place. Oh, yep. It doesn't matter.
So one more, I guess, I mean, it's back to policy. To say someone from housekeeping calls off. Well, they're all friends on Facebook, and they called it within their 2-hour period. But all of a sudden, Susie says Jane's on a boat.
Okay.
So when she comes back to work, can
Absolutely.
we say Susie he was on a boat?
Absolutely.
Yeah.
Can she say none of your business?
Not if you put the information on social media.
But it's personal.
Doesn't matter.
But it's not public.
It's public.
Yeah. But what if she has paid time off?
Well, then it doesn't matter.
Right.
Yeah, I mean, as long as, if you have an employee.
Yeah, it's season, you're needed, we're already short-staffed, you're screwing Susie, and now Jane's on a boat.
Yeah, no, absolutely. If they have, it doesn't matter what they do on their free time, as long as they're not violating some company policy or some social norm of the company. I mean, if you work for Hobby Lobby and you've got somebody out there picketing for something that they don't believe in, then you might have an issue. But generally, if they put it on the internet, it's not protected under the concerted activity section that we talked about. Okay, it's not something about the, their pay or anything like that. You can discipline them or fire them based on what they posted. Yes, sir.
This is really good. I got a lot out of it. Do you have any online content or anything else that you talk about? Maybe just some content I could look at.
I mean, it all depends on the specific subject. I would shoot me an email. If you have specific questions, I'm happy to answer the question myself or point you in the direction of an article that I've drafted or some article that somebody else in the field has drafted. We got a lot of folks in our employment law department that do this stuff day in and day out because a lot of what you run into when it relates to social media is what can you control as it relates to your employees, what can they post, when can they post it, what the policies need to be. And so there's a ton of stuff out there. So if you shoot me an email on any given subject, I will get back to you, I promise, with whatever it is that you need. Yes, ma'am.
Reputation management. I know that there are firms out there that you pay them a certain amount of money and they claim to delete your whole life off of the internet.
Sure.
How effective is that?
Depends on how much money you have. I mean, no, seriously. I mean, it's absolutely possible. You're never going to get rid of everything, in my personal opinion. Just from the cases that I've worked on, where we've dug into individuals' background, if you have enough time and money, you're going to find something out there. And a lot of these sites make money off individuals trying to clean up their reputation, like these mugshot sites. To get your mugshot off a mugshot site can be $5,000 per site. I mean, it's insane how much they charge. And so I can tell you that they can do a pretty good job. You know, maybe your mugshot doesn't show up on page 1 of a Google search, but if somebody does enough digging, they're going to find something.
Yeah, I heard
Yes,
I heard there was companies that like they take Facebook content and they store it for, like you said, hound dogs, stuff like that. They
Sure.
store all of it, even if, you know, I guess if you keep it private, maybe not, but it's accessible to people.
Absolutely. There are web archiving companies that do exactly that. They go out and preserve social media as it stands for potential use later on. Yes,
One
ma'am.
of the things that I found with regard to what you just said, you have a username like for Instagram and whatnot. I did an actual search on my username, just a little thing, and it came up and people were actually using my pictures from Instagram and then referencing, and it's like on 5 different sites. And then there's another site that shows my entire Facebook profile, and it'll show my friends, and my friends are private on my Facebook. It'll show all my friends, it'll show how active I am on social media, and it'll show the pages that I visit.
And it's really interesting. It's a great point, because even if you have a private social media account through one of these sites, a lot of times you can backdoor your way in. Okay, I can't tell you the number of times that I've had an individual who's got a private site, or they use a completely fake name, and then I find some medical record where they list their next of kin, and I find their mom's social media site. And of course, their mom's social media site is completely wide open, and then you can backdoor through, hey, mom's friends with the guy or the gal, you can backdoor your way into their site. So even if you think that you're totally private, you may not be totally private, and the information's still going to get out there.
Sorry, last.
No.
This is so interesting. Okay. Some people will have a website. The website will be xyz.com.
Sure.
Then they have a business email, stephanie@xyz.com. Now, I've seen that as well as people who have a Gmail account, xyzbusiness@gmail.com. Does that, I mean, being that Gmail could be a personal account, if you get sued and you get subpoenaed for emails, well, it's not through the website. How can you prove that?
So that's a kind of a tricky question. So if you get a subpoena for emails, the subpoena should usually designate the email addresses from which they're requesting the emails. So they should say, I need any and all emails from September 1st, 2010 to September 1st, 2015 from john.miller@henlaw.com. And then if you have custody and control over that server, your obligation is to go in and get those emails. Now, if you get an email that says, I need emails from some Gmail account that you don't have custody and control over, what you can do is respond and say, you've got to go to Google. You've got to get that. So you have to send the subpoena to the entity that controls the server for the email addresses. All right. So if you want Gmail emails, you can either ask the individual to send them everything that you've got, or you can go straight to Google. If you want something from HenLaw, which is the Henderson Franklin website, you just need to send it to Henderson Franklin. Does that make sense?
Yeah, so there's no hiding. Like certain people will have emails on a corporate server and then they have 30,000 private emails and then they delete those, but
Sure.
they still get in trouble.
Yeah, one of the first things we ask in all of our written discovery requests is list every email account that you ever used for the last 5 years. And then that way you know, and you can subpoena emails from each of those providers. So, yes.
One more random question. So
Yeah.
we had a housekeeper, didn't show up, blah, blah, blah.
Was she on a boat?
Online, saw a mugshot.
Okay.
They weren't on a boat this time. So there's a mugshot, and here they were arrested for DUI, blah, blah, blah. How long does an employee have before they have to tell an employer they got in trouble by the law, and did they have, or does it depend what they were charged with?
What's your employee handbook say? There is no obligation for an employee to ever inform an employer about a criminal conviction, a criminal arrest, unless there is something either statutorily, which there is very little, if you work for, say, a school district or something like that. Right. But unless it says in your employee handbook, hey, you've got X number of days to report this, there's no obligation.
And you recommend, of course, for an employer to have some kind of.
Oh, absolutely, yeah. Even more important than a social media policy is some sort of employee handbook. So, all right, everybody good? Email me if you have more questions. I'm